Dan. Um, his vision was to present useful information on diverse topics and timely issues that fulfill our mission to educate, enjoy, and engage. We are about to finish our 13th session. It is easy to register for any class. Simply access our website at empoweruohio.org. Scroll down to the class and click on the register link. If you'd like to provide your email address when you come in the evening, you'll receive an email just on every class, and you can register off of that. Most of our classes are presented virtually online. Go to the website 10 minutes before start time and click on the Join in Class link. You can also watch many of our classes at a later date. At the end of our program, there will be time for questions from those in attendance as well as our virtual attendees. We just ask that you wait till we bring a microphone to you so that those online can hear your questions. Empower U is a free university powered by donations. The costs incurred include website, constant contact, printing and advertising, virtual, some speaker, and personnel expenses. To allow us to continue offering these classes, we always pass a bucket towards the end of our class, and we welcome any small donation and thank you for understanding the costs that we incur. Please feel free to provide any comments or feedback on any session you've attended. We're also interested in valuing your opinion on our speakers and any ideas that you have for classes. We'd like to hear from you. You can reach us at info@empoweruohio.org. Thank you for attending tonight's session. And now I would like to introduce our Executive Director, Anita Thomas.
Thank you, Betty. And let's give Betty a round of applause here for everything she does. And I'd like to acknowledge a few other Amy Sander, who's our operations manager. Andy, our producer in the back. And Bill Roll and Bill Moore, who are here at every session, always helping us. I don't know what we do without these guys. So I want to talk about the few sessions we have coming up. Can you guys hear me okay? Okay, the next one we have is next Tuesday night at Price Hill Chili, which is with Todd Fortune. Now, I don't know how many of you live in Hamilton County, but if you do, you might be really interested in coming to this one. Todd's going to talk mostly about transportation. I think if you live on the west side, you'll know that we're probably going to get around to the Western Hills Viaduct. And so I think it's going to be a very interesting one, and it's an opportunity for you to get your ideas told to Todd Fortune. Sometimes it can be hard to get to those guys. And so, and you know there's great food at Price Hill Chili, right? So come on over and have a beer and some food and thank your voices heard. And the next one after that is Uncontained Container Gardening, May 18th. And that's in Anderson Township Homestead. This is, have any of you seen the Anderson Township Homestead here? It's just beautiful. It's like a walk back in time. And the class is going to be in the old barn. And I highly recommend you coming. It's just going to be a wonderful evening. Learn about container gardening, and it's going to be a really relaxing, nice evening, and it's in a beautiful setting. And then our end of season cookout celebration is here on June the 7th. We're having it here, so if we get rained out, we know we can come in here, because last year we got rained out and we had to cancel, and we don't want to do that again. So if you're free that night, please come, please come, because we'd love to see you. And the last one I want to mention isn't on the list. We're doing one June the 17th. It's a Saturday from 10 until 3. We're partnering up with Building Blocks for America and AFP, and we're doing a Constitution boot camp in the studio here. And I'm trying to let everybody know early, so if you have children, I wouldn't recommend little children because they go pretty fast and they go for 4 hours, but middle school, high school, millennials, college kids, this is a great, great class. And we'll have this up on our website pretty soon. to register for this one. So now I would like to introduce our speaker, who I am so happy to have him here tonight. And Matt Byrne is the president of the Cincinnati Lawyers Chapter of the Federalist Society. He's on the advisory board of the, how do you say that, Matt? I don't want to say this word wrong, I'll say it. The Federalist. It was right. Okay, I thought it was wrong. And he's a member of the Central Committee of the Warren County Republican Party, and he's on the Education Commission at St. Margaret of York School. He was also a participant in the American Expertise Institute Fall in 2015. Matt previously worked with George W. Bush's White House as a staffer in the Office of Presidential Personnel. This office is responsible for finding candidates to recommend to the president for appointment or nomination. That's pretty important stuff there. During law school, he clerked for the acting general counsel of the United States Department of the Treasury. For the last decade, he has practiced labor and employment law, representing and advising employers in Cincinnati. He is currently the president of the Cincinnati Lawyers Chapter of the Federalist Society for Law and Public Policy Studies, and he is actively involved in leadership roles with several other community and religious organizations. Matt lives in Deerfield Township with his wife and 3 children. And one last kind of little story I want to tell before we get started. Matt was on the radio before he came in here, and Brian Thomas asked him, "How long have you been studying this?" And Matt said, "Well, I'm going to tell a story on myself, but I was actually reading the National Review in the 8th grade." So that might tell you a little bit about how long Matt has been interested in that sort of thing. So we are going to have, Matt, you want to pull this? Door prize.
All right.
Did everybody see that amazing Constitution frame back there? That's what you get, is that Constitution. Okay, the last 3 numbers is 681. 681? Going once? Going twice? Did everybody check their tickets? Matt, you might have to have a do-over.
Okay.
Okay. Yes. Is that you? Well, here. Betty, you want to bring up I want everybody online to see this amazing door prize we have tonight. It's a framed Constitution, and it's framed here in Frame USA, 100% American made, everything. Is that amazing? Yeah, so thank you very much. And now I think we will start with letting Matt lead us in the Pledge of Allegiance.
I think got this on. Yeah. I don't need it. Okay. Sorry, where's the flag? You have a flag?
Can't we get it to work now? Oh, where did the flag go? We had a flag up there. The flag left?
Well, that's okay. We'll just go ahead without it.
So I have to be the flag. Okay?
I pledge allegiance to the flag of the United States of America and to the republic for which we stand, one nation, under God, indivisible, with liberty and justice for all.
That's what happens when you're live, Matt.
That's okay. All right. Well, thank you, Anita and Dan and the entire board of Empower You. I really appreciate you all having me here to talk about Justice Antonin Scalia. I just want to make one quick comment, which is that your organization's this motto on its logo, next steps for the citizen. I'm sure you've gone through this all yourselves many times, but I think it's a great point to talk about informed citizens, because Justice Scalia, being a conservative, I think would very much appreciate the idea that we've gotten, unfortunately, away in this country from the idea that of what Alexis de Tocqueville and other thinkers would talk about in terms of little platoons. We should be a society that has the individual, not just the individual in the government, but the individual, the government, churches, standalone organizations like yours. And what you're doing, I think, is very much in that spirit of an American society that is made up of numerous organizations doing things to better the community. And I really appreciate that. Now, Justice Scalia, I guess it's not up quite yet. I'm going to look at the PowerPoint on my screen. I'm sure all of you have, of course, heard his name, or else you wouldn't be here. But Justice Scalia really was one of the most influential and important justices on the United States Supreme Court in its history, period. If we look back over the course of American history, there have only been, I should have looked up the number, I think it's about 150 or so individuals who have served on the Supreme Court. And even with such a small pool, most of their names are not known to most people. But in Justice Scalia's case, his passing was a national event. People knew who he was, knew that his absence from the court was a significant turning point, and something that a lot of people cared about. And so what I want to do today is talk about who was he really, beyond just the headlines that you may have read, something about his opinions. Who was he really as a person, his family life, and what did he really believe, and what did he really demonstrate and do through his opinions on the Supreme Court? Now, I'm a very linear person, so I think I want to tell you in advance, here's the topics I want to cover. And if you have a question, feel free to type up and ask a question in the middle, but we'll also reserve, I think, some time for questions at the end. We're going to talk about Justice Scalia's life, his approach towards the Constitution, known as originalism, his approach towards statutory interpretation, textualism, and his rejection of the idea that we should look at legislative intent. We'll look at his approach towards regulations and the Chevron doctrine, which is kind of an evolving issue for conservatives. His reverence for what he called the structural constitution. His belief that when it comes to the act of judging, to looking at the text of the Constitution or looking at text of the statute, there should actually be an objective right answer that we're trying to find. It's actually a concept that many judges would reject. Also, I want to touch briefly on the fact that when we talk about politics and when we talk about the law through a political lens, we tend to put people in this, there's conservatives and liberals. But actually, there's, of course, variations within those groups. And there have been some variations among conservatives on the bench between Justice Scalia and some of the other conservative justices. And then I want to talk about his effect on judiciary, on lawyers, on law students, which he would say is the most important. And then also about the role of his faith in his life and in his work as a judge. And I should maybe also just quickly mention, I'm going to talk about his legacy, but I think it's pretty clear from a number of interviews that he gave over the course of his life that he would probably scoff at this discussion. He frequently said, I don't care at all about my legacy, and would not talk about it, said it doesn't matter, people can hate me, I'm fine with that. If people hate me 100 years from now. Oh, it is up now, okay. How do I advance this? Oh, thank you. All right, so a little bit about Justice Scalia's life. He was born in 1936 to Italian, his father, I believe, was an Italian immigrant, which was actually a significant thing when he was confirmed. All right, I don't know if I'm standing in the wrong place. Seems to be okay here, so I'll try to stay put. Of course, when he was not in the Supreme Court, the fact that Justice Scalia, Italian, was a significant biographical detail that was much talked about at the time. He's the first Italian American to serve on the Supreme Court. He grew up in New York City, went to Catholic high school, a Jesuit high school, and this little detail I think is uh, one that sometimes surprises people. Justice Scalia talked about the fact that, and I don't know if this is on, but I'll try to speak louder. He talked about the fact that he was actually part of, I believe it was the riflery group at his high school, and he actually took a gun to school every day. Took it with him on the New York subway, which is something that, of course, would leave most people aghast today. But it was an ordinary, normal part of life. And he talked about that, I believe, in connection with the Heller decision on the Second Amendment. He ended up going to Georgetown University for his undergrad degree, to Harvard Law School for his law degree. He then, the most significant job after law school is he worked with a law firm that's now called Jones Day, had a longer name at the time, in their Cleveland, Ohio office for about 6 years. He always knew, though, that he wanted to be a law professor, and he was able to get a position at the University of Virginia for a few years. He then left. He was appointed to head up or be the general counsel of the Office of Telecommunications Policy under the Nixon White House, appointed by President Nixon. In that role, he was actually involved with creating some of the early rules regarding cable television that would influence its development. He had several other roles in the executive branch under Nixon and President Ford, including a stint as the Assistant Attorney General in charge of the Office of Legal Counsel, which is really a very, very significant role in the Department of Justice that deals with a lot of the very hot-button, important government structure type issues that he would eventually deal with on the Supreme Court. After the Ford administration ended, he became a law professor at the University of Chicago. For several years, he spent a year visiting at Stanford University. But at the University of Chicago, the role that he had that appeals to a lot of us Federalist Society types is he was the first faculty advisor of the chapter of the Federalist Society that was formed at the University of Chicago. So he was involved in our organization from the very beginning. He was appointed to the United States Court of Appeals to the District of Columbia Circuit by President Reagan, served on that for just a few years, and then was, of course, nominated to the Supreme Court in 1986 and served until his death in February of 2016. But I think one thing that really bears a lot of mention is his family life. Justice Scalia and his wife Maureen were parents to 9 children, all of whom have gone on. This is a picture that was taken, I believe it was around the time of his confirmation hearing. All of his children went on to do some really impressive things. We have their attorneys, poets, people in the business world. One of his sons is a Catholic priest in the Diocese of Arlington. It's a very accomplished and very close family. And this speech or this presentation, I want it to be about who was this man and how did that impact his judging. So I don't want to talk just about his cases. I think there's a few just quotes that are worth sharing regarding his family life. In a speech to law students that he gave a few years ago, Justice Scalia said, "Try to find a practice that enables you to maintain a human existence, which should include time for your family, your church, your synagogue, community, Boy Scouts, and Little League." And that quote speaks to my heart as an attorney. So many of us, especially at large firms, struggle with that issue. And there's very much in the legal world an idea that, especially on the coast, well, every second of your life you should need to go to the law. And as much as we may enjoy the law, Justice Scalia, I think, very much emphasized the idea that there's more to life than just your career. His son, Christopher, who's a writer, talked about, actually this was a quote from a clerk, but Christopher's the next slide. One of his clerks pointed out that when he clerked with Justice Scalia used to tell his clerks that once you get out of here and you're practicing, be home for dinner. Children are civilized at the dinner table. And that type of, I think, human element is important to understand with son Christopher talked about uh, life at the dinner table in the school at home. And Justice Scalia, he said, of course, with his kids, wanted to talk about law and history and politics at the dinner table. Christopher talked about dads running gags, ensured that a kitchen would never be mistaken for a salon, and that's the next salon. Poor conversationalists got it worse than an unprepared lawyer during oral arguments. If anyone said Dad would leave a chorus of ums to spotlight this oratorical shortcoming. Sometimes the umming would spiral into omission, as thus spoke Zarathustra. And this little anecdote, I think, encapsulates a lot about what lawyers know about how Justice Scalia conducted himself in the courtroom and through his written opinions. This is a man who focused very, very much on absolute precision in his writing. The people who I know, I never grew up with, I know some people who clerked for him, and he very much emphasized that writing was a difficult, torturous, very precise process of making sure that his written opinions said exactly the right thing. No ums allowed. Also, the reference to his spiraling into a rendition of Thus Spoke Zarathustra. Justice Thomas and others talk about the idea that Justice Scalia, very much who loved opera and things like that, who loved performance, and sometimes he would perform essentially by reading his opinions out loud to his clerks and other justices, so we could appreciate just how well they were written. The judge also, I think it's important to note, was not, as I said, limited just by politics. And that's really seen, I think, through his very close personal friendship with Justice Ruth Bader Ginsburg. Justice Ginsburg, of course, is one of the, I think, one of the most well-known liberals of the left-wing side of the Supreme Court bench. She would not dispute, being called a liberal, I'm sure, or progressive. But Justice Scalia and Justice Ginsburg were very close. She was his best friend on the court. That's a picture of the two of them on an elephant in India in the 1990s. They and their spouses took a vacation together, and this picture, I think, says something about the idea that politics is not everything. Human relationships should extend beyond simply those who agree with us. But let's get into the law. When we look at the Supreme Court, I think it's important to think about, well, what is the Supreme Court's role in our legal system? Most of us, if we encounter the court system at all, do so through trial courts, through local, probably state courts, that are dealing with issues that are actually going to be tried, either to a judge or to a jury. There's a decision that's issued, reached by the jury or the judge, and that's the end of the case after a long discovery process, issuing documents, that type of thing. Supreme Court, of course, plays a different role. Once a case is decided by a trial court, it's appealed to an intermediate court, both in the state and the federal system, and from there, at least in the federal system, to the United States Supreme Court. So when a Supreme Court justice is looking at a case, they're not looking at the facts. The facts have already been decided. In both the state and the federal system, facts are decided at the trial level, and once they're decided, that's essentially the end of the discussion of the facts. The issues that reach appellate courts are issues of law, and therefore, they're often issues of interpretation. And let's take a step back and think about, I guess, the legal world that Justice Scalia came into when he was appointed to the Supreme Court. After many years of Justice Brennan and others on the court who really espoused the idea of the living Constitution, there was essentially no other mode of interpretation through the 1960s and 1970s. Everyone agreed, essentially, that the Constitution is a living document, that we look at the intent behind it, we look at what's best for our society, how can we make the words of the document and how it's applied fit our conditions today. That was essentially the governing mode of constitutional interpretation in this nation for everyone. And there were individuals appointed by President Nixon and President Eisenhower, Republicans, who espoused that view too. It was essentially undisputed, except on the margins. Well, one of those people from Vargas, Justice Scalia, ultimately made it to the Supreme Court. And he really brought a challenge to the idea of living constitutionally. This quote here is from a 2006 speech that he gave to the Federalist Society, in which he said that the idea of a living constitution, that's the argument of flexibility, and it goes something like this. The Constitution is over 200 years old, and society has changed. It has to change in society like a living organism, or it will become brittle and gray. And then he says, but you would have to be an idiot to believe that. The Constitution is not a living organism. It is a legal document. It says something and doesn't say other things. And that really was a very significant idea, those last couple of sentences. The idea that the Constitution is something, and that thing doesn't change unless it's amended, is very significant when it comes to how you look at the document and the outcomes that a judge will reach. This was the lodestar of his approach towards interpreting the Constitution. And well, I'll get to that in a moment. Let's talk about another idea, just to dispel it real quick. Most of us, if we watch the news or read the newspaper, when it talks about Justice Scalia or Justice Thomas, when most Republican presidents or presidential candidates talk about, well, here's who I promise I'm going to appoint. What phrase do they always use? Strict construction. But Justice Scalia not only wasn't a strict constructionist, he rejected the idea of strict constructionism, as do essentially all judges who we would, at least colloquially, refer to as conservative. Strict constructionism really isn't what we're thinking about when we think about judges like Scalia. As he wrote in his book, A Matter of Interpretation, that I am not a strict constructionist, and no one ought to be. Text should not be construed strictly, and it should not be construed leniently. It should be construed reasonably, to contain all that it fairly means. And he referred to strict constructionism as a degraded form of textualism that brings the whole philosophy into disrepute. Instead of strict constructionism, he was an originalist. And really, when we talk about strict constructionism, that's what we really mean. He's an originalist. And originalism as an interpretive lens through which judges can make decisions about what the Constitution means really was an idea that started to be developed several decades ago through debates among conservative legal thinkers, Justice Scalia being one of them. And it went through a couple iterations. It started out kind of focusing on the idea of original intent. Let's look at what the founders intended when they wrote the document. But really, that idea got refined. And I think the more widely held approach towards originalism, the approach that Justice Scalia took, is original meaning. We need to look at what the words that are in the document meant at the time they were written. Because those words, as understood, were what was ratified. They were what was passed by the Constitutional Commission. They were what was voted on by the people who were able to vote in their state ratifying convention. That's the most democratic approach to the act of judging. The idea is that, and maybe I should read this quote here, he says, the Constitution that I interpret and apply is not living but dead, or as I prefer to call it, enduring. It means today not what current society, much less the court, thinks it ought to mean, but what it meant when it was adopted. He also, on another occasion, talked about the whole purpose of the Constitution is to prevent change, to embed certain rights in such a manner that future generations cannot readily take them away. If the intent is ultimately to protect rights, the meaning can't change over time because the meaning protections change. And Justice Scalia used, there's three words here that are an example. He talks about you have to look at what the words meant at the time they were written, and in this case ratified, because words change too. He used the example, think of the words awful, artificial, and amusing, all of which had very different definitions just a couple of hundred years ago. Awful meant something that inspires awe, that fills you with awe and wonder. Artificial meant something that was very artistic, that had a lot of kind of artistic value. And something that was amusing was something that was thought-provoking, that led to deep discussion. These words mean something different today. If they were in a legal text, the text that was still in effect, how should we interpret them? Well, what they meant at the time they were passed. Those words aren't in the Constitution, but it's a good, I think, example of his point that, yeah, things change, but the only way to know what the Constitution really means is to look at what it meant at the time. And it's about democracy, ultimately. Justice Scalia talked about, and other originalist thinkers talked about the idea that the court is not a legislature. The court is not there to decide what the law should be, just to say what it is. Ultimately, that serves the people by giving them their rights, the democratic rights, by protecting them. Because every time that a court makes a decision to say, we've decided that this new right exists, or that right was never understood properly, what they're ultimately doing is taking something away from the democratic process, taking away the people's ability to make change. So when judges approach these issues, they have to be very reserved and ultimately stick with what the people passed through the constitutional process. Originalism it doesn't come into every Supreme Court opinion that Justice Scalia wrote. Not every opinion deals with constitutional law issues. But it came into a number of significant decisions. For example, in District of Columbia versus Heller, that dealt with the individual right to bear arms from just a few years ago. He pointed out that the first phrase in the Second Amendment talks about a well-regulated militia. And if we're going to understand what that means, we have to look at what was meant by a well-regulated in the founding era, rather than by what we would refer to today. In Kylo versus United States, this was a case where the police had used a thermal scanner to look at heat inside a house. And if I remember correctly, I think they were looking for marijuana law. So it's been a while since I read the case. But they were trying to find criminal activity through looking at heat imaging. And the question was, is that a violation of the Fourth Amendment right against warrantless searches and seizures? They didn't have a warrant. And Justice Scalia said, in his opinion, that this is a technology that didn't exist at the time the Constitution was passed. But we can still decide this issue based on the original meaning of the Constitution by thinking about how this power technology shrinks the privacy right that was guaranteed. So look, what was the right that was being protected at the time? What did the Fourth Amendment mean when it said we have a right against warrantless searches and seizures? And how do we apply that to this new technology? This is an important point because a lot of the critics of originalism say, things change. How can we possibly apply what was written in the last decade or two of the 1700s and apply it today? It's just worthless. Well, this is how. You look at what the words mean at the time, what the rights were that was protected, and we can even use those terms to look at how rights are protected when new circumstances arise. In Casey versus Planned Parenthood, Justice Scalia said that the role of a judge is essentially lawyers' work of reading text and discerning our society's traditional understanding of that text. It's not the role of a legislator deciding what my preferences are. That's key. The role of a judge is to reach a conclusion based on what the law and what the Constitution actually says, not the decision that the judge may prefer. We'll come back to that idea in a little bit. Now, the other big, I guess, interpretive lens that Justice Scalia really had a significant impact on is with regard to the interpretation of statutes. Because when we're interpreting the Constitution, it's one thing. It's a little different when you're interpreting a statute passed by Congress. And when Justice Scalia joined the bench, the idea that we're going to look at the text of the statute to figure out what Congress meant and what the law is was not really held by much of anyone. When it came to judges or law professors, he came to the court and was one of the primary individuals who promoted the idea that if a judge is interpreting a statute, we're only, or almost exclusively, going to look at its text. And we should not be focused on legislative intent, because for a long time the idea had been that, well, if we're trying to figure out what Congress meant and what the law is, we've got this issue in a statute that's a little unclear. Well, how do we resolve that problem? For a long time, the idea was, well, we try to figure out what Congress means. The law's unclear. I don't know what that statute means. Let's just figure out what they were trying to do, and then we'll make a decision based on that. And Justice Scalia really forcefully argued that that's a very flawed approach to law, because it's really just a masked use of the judges on trials. Because how do you really determine what legislative is? Each bill that's passed by Congress is voted on by up to 535 members of Congress, 435 in the House and 100 in the Senate. Even if you're only looking at the majority, if you voted for the bill, how do you know what they all intended? Did they all intend the same thing? Did they intend something different? Did some of them vote on the statute without even reading it? They did. They didn't even read it. How did they have an intent as to what it meant? If their staff handled the bill and said, okay, we worked this issue out, Congressman, vote yes. How did that member of Congress actually form an intent as to an issue that's in dispute? And his response to that was to say, we really can't look at legislative intent, because what ends up happening is you've got a speech by Congressman A, and I've got a speech by Congressman B, and you've got a committee report, and I've got this other committee report, and they conflict. So I'm going to resolve that. What I'm really doing is deciding what I want the statute to say. He said we have to put all of that aside and instead focus on what the text is. And if we look at what the text is and do our best to figure out what it means and what the law therefore is, that's the right role of a judge. And sometimes that might lead to a result that people don't like. And it might even be that maybe you're wrong and Congress didn't intend that result. But that's Congress's job to focus, not the focus. In this Graham County Soil Water Conservation District case, Justice Scalia pointed out that the Constitution gives legal effect to the laws Congress enacts, not the objectives its members aim to achieve in voting for them. There's also an important constitutional point here. Well, what are the laws of the United States? There are things that the laws of the country are things that went through what's called bicameralism and presentment. A bill is passed by the House, it's passed by the Senate, it's been presented to the president and signed. Anything that didn't go through that process isn't a statute passed by Congress. And therefore, it's not the law of the land. And if we're talking about, well, the Energy and Commerce Committee had this report that said the statute meant X, that committee report didn't go through bicameralism and it wasn't signed by the president. It might not have even been read by any senator, let's say if it's a House report. And he talked about the idea that it's simply not compatible with democratic theory that laws mean whatever they ought to mean and that unelected judges decide what that is. This corrosion of democracy occurs even when the law revising judges are elected, because 5 or 7 or 9 members of the state Supreme Court, lawyers all, can hardly be considered a representative assembly. Judges aren't our representatives. They're merely there to say what the law is. Talk about this issue. Now, the thing is there are more laws than just statutes, right? We all know about regulations, and they are the law of the land. We can get into a whole, I think, debate about, well, what's the history of delegations and administrative agencies, and that's actually a very hot topic right now. But for the courts, the issue for a long time has been that ever since, let's say, the mid-20th century, more and more and more, Congress isn't passing detailed laws. They're just saying, here's our generic law. Here, executive branch agency and the president, you can figure it out, fill in the gaps, pass regulations. And administrative agencies have run with this. As you know, we have thousands upon thousands and thousands of pages of regulations, more issued literally almost every day. And for courts, the issue for a long time was, it is, how do we know if a regulation was properly issued? Because it can only be a valid law if it's ultimately consistent with the authority that is delegated to that agency by Congress. There was a case, a very, very important case called Chevron Chevron Usa Inc. That was decided in 1984, 2 years before about 2 years before Justice Scalia joined the Supreme Court. So he wasn't involved in this decision. But for the last 25-ish years, however long it's been, this has been the leading decision on how courts should approach regulations. And the court said, one, you go through a two-step process. One, has Congress talked about the issue that's being regulated? If it has, is Congress's intent clear? If the intent is clear and the regulation is inconsistent with the intent, then the regulation is valid. But if it's unclear, Congress hasn't really specifically talked about that issue. Is the regulation, the courts should defer to the agency's regulation as long as it's a reasonable interpretation of what they think the statute meant. And Justice Scalia, this goes to the point that I mentioned earlier, that even among really committed people and conservatives who care a lot about the law, there can be change and debates. Justice Scalia was actually a big proponent of Chevron, particularly earlier in his career. He had been an administrative law professor, in other words, a professor who deals with regulations, and he thought that Chevron was a good idea, that it was a good way for the courts to control the regulatory administrative state. And he said things like, well, Chevron's good because it provides a background rule of law or regulations against which Congress can legislate. And he said Chevron's good because legislators don't have to gamble upon whether, if they say nothing about it in the statute, the ultimate answer for an interpretive question will be decided by a court or an agency or whatever. He thought it provided a good structure. Towards the end of his life, there was a little bit of indication that he might have been changing his opinion on Chevron. And that's actually a really important thing because, as many of you know who followed recent political debates, I think the whole conservative world has kind of decided that Chevron really was a failure and that courts need to be more strict in their approach towards whether a statute is really consistent with statute or whether a regulation is consistent with statutes or not. And you see a little bit of this changing opinion in this decision called Our. And this is really important. In Our, the Supreme Court was looking at, well, if an agency is interpreting its own regulations, and in that case, if I remember correctly, I think it was the EPA, was saying, well, our regulation means X. Should courts defer to that or not? And in 1997, Scalia wrote in the majority opinion that the ultimate criterion in interpreting regulations is the administrative interpretation, which becomes of controlling weight unless it's plainly erroneous or inconsistent with regulation. He was saying, unless the agency is crazy, we're going to defer to what the agency thinks this regulation means. But in 2015, and this wasn't the first time, Scalia had changed his view. And he said that actually the Supreme Court should abandon his decision in Our. It was too deferential to the administrative state. There's really some change in development in his thinking on this point. Sorry, my computer's not synced with the screen, so I'm sorry I'm a little behind sometimes. And here's another big issue that I think we need to talk about. It really pertains to a lot of our current political debates. Justice Scalia was well known. He said this a number of different times, that when he was asked the question, well, what is the most important part of the Constitution? Let me back up. When most of us are asked, what's the most important part of the Constitution? Most people, if they can name any part of it at all, are going to say something like the First Amendment, the Second Amendment, the Fourth Amendment. It's going to be one of the amendments in the Bill of Rights, most frequently. And Justice Scalia said, wrong. Every tin-horn dictator in the world today has a Bill of Rights, every banana republic. The first thing you do when you seize powers is to promulgate a Bill of Rights. In the so-called world, community applause. As long as the real Constitution, I'll stop there. His point was, and I think he used these specific examples, the Soviet Union had a wonderful Bill of Rights. There's dictatorships all around the world which guarantee wonderful rights to their citizens, but they don't respect them at all. And that's why he argued the most important of the Constitution isn't the Bill of Rights. It's the Articles 1, 2, 3, 4, 5, the parts of the Constitution, the main body of the Constitution itself, that deal with the structure of government. Because it's actually the structure of government and the checks and balances and the separation of powers that the Constitution provides for that really protects those rights. He said that as long as the real Constitution does not prevent centralization of power in one person or in one party, you can ignore the Bill of Rights. He said in structural cases, that's what's crucial. Excuse me. His point was, as long as we really respect the structure of the Constitution, the rights that are given not by the Bill of Rights, but just recognized by the Bill of Rights, rights given by God, those rights are better protected if we are consistent and fair in how we approach constitutional structure issues. And I think at least among attorneys, or maybe among conservative attorneys, one of his most well-known decisions, touched on this issue, Morrison v. Olson, decided in 1988. He was the sole dissenter in the case. He was the one who lost badly. And this was a case dealing with the independent counsel statute. I'm sure we all remember Ken Starr, President Clinton. There were independent counsels during the Reagan administration. I don't know how many there have been, but there's been a number who've been appointed over time. And the statute was based on a noble idea. If we have wrongdoing in the executive branch, if the president's doing something wrong, cabinet members, high up executive branch officials, the idea was, well, we can't trust them, the Department of Justice, to investigate. We can't trust the executive branch to investigate itself. We have to have this outside individual who's appointed by the president, but not really accountable to the president, an independent counsel. And the statute was challenged on separation of powers grounds, and 8 of the justices said, no, this is a legitimate constitutional system. We can have an independent counsel. Justice Scalia disagreed, and in fact, in an interview I remember reading from him in 2013, I think he said that his loss in this case was one of his, I guess, those heartfelt losses that he regretted the most. He said, this is really about power, and the allocation of power among Congress, the president, and courts in such fashion as to prevent the equilibrium the Constitution sought to establish. His point was, the Constitution gives executive power to the president. It doesn't say the president gets some of the power, or the president gets most of the power, and some of the executive power is kept for an independent counsel. It doesn't say that. So the president has to have authority to hire or control an independent counsel if he's an executive official. This decision is really key because I'm sure if you asked him, he probably would have said, yeah, the intent's noble to have this outside person investigating the president. He probably would have agreed with some of the investigations that independent counsels conducted. But what we agree with isn't what should determine whether something's constitutional or not. Whether a noble purpose exists shouldn't determine whether something's constitutional or not. And he found that the independent counsel system was unconstitutional when sole dissent in that case. He talked about the idea, too, that we're trying to get to the right answer. In an early speech, and he repeated this a number of times, he said, I wish I had a stamp that said, stupid but constitutional. Because again, just because I disagree with something, and this is a man who, he's admitted conservative. He talked about how he canceled his subscriptions to the New York Times and the Washington Post. He was liberal and he read the Washington Times. Very conservative man. Sometimes you can be a conservative, but as a judge, have to recognize my goal when an issue comes before me isn't to say whether I agree with this statute. It's merely to say, is it constitutional, is it interpreted correctly, those types of things. So there's lots of times he would like to be able to say, stupid but constitutional. I think this law is a bad idea. It's going to have bad effects on the country. It's not against the Constitution, so we're not going to strike it down. You can imagine the converse stamp. This is a great idea, but it's not constitutional. Shouldn't be allowed. He talked about I remember an interview, he said somebody did actually something like that once. So he got it good. And he gave an example. If I were king, I would not allow people to go about burning the American flag. However, we have a First Amendment which says that the right of free speech shall not be abridged. He was a true patriot. I think really believed him. That the idea of flag burning would have disgusted him. But he knew that as a judge, His job is to respect the Constitution, enforce the First Amendment. You can't have a statute that prohibits flag burning, etc. He talks about if you're going to be a good and faithful judge, you have to resign yourself to the fact that you're not always going to like the conclusion that you reach. If you like them all the time, you're probably doing something wrong. This was talked about a lot during the confirmation of now Justice Gorsuch. And it's something that I think we as voters have to keep in mind. That we can get upset about members of the other party, members of our own party, and sometimes it feels like we're losing, we're losing, we're losing. Well, and the other guys are violating what we think the Constitution says. They're doing things that we think should be illegal. And eventually, I know people like this. You talk to them and they reach a point and they say, we're losing because they fight dirty, so we need to fight dirty. And we can set all these principles. As long as we're committed to our principles, we're losing. Set them aside. We're not going to be principled. We need to be just as vicious and dirty and unprincipled as the other side, and we'll get the policy goals we want. And that's the wrong approach. I'm saying that as I'm making a normative claim here. I'm saying, well, that's a bad idea. But it's also, as a legal matter, very inconsistent with the approach that Justice Scalia really championed with regard to the law. We don't set aside what the law says. We don't set aside what the Constitution says whenever it's convenient to get what we want. And sometimes that means we'll have to lose. But it's more important to preserve our overall system of government, these checks and balances that we have, separation of powers, than to set those things aside just for a short-term gain on a particular policy issue. Now, excuse me. I think that point bleeds into the next. It's especially, okay, in Ohio, we have elected judges. You know, the federal system, they're all nominated by the president, confirmed by the Senate, and they serve for life. In Ohio, we vote on our judges. And sometimes we have election campaigns where you get into a debate about, well, was Judge Smith right or wrong about that issue? And yeah, people can consider that issue. We can consider whatever we want as a voter, right? We're free to cast a ballot for whatever reason we choose. But sometimes I think it's important to remember that judging can actually be hard. You know, when you look at an issue that you care about a lot, it can sometimes be easy to say, well, clearly that's me. Everybody else is just stupid. Who reaches the other conclusion? But it's actually the case that sometimes these issues can be kind of hard, and there's shades of, well, is this the right result, or is this one they're so close? I'm not sure. And you actually can have people who really hold the same principles who disagree sometimes on the outcomes in specific cases. And for example, Justice Scalia and Justice Thomas, who I think they would both admit are the only two who truly use originalism as a overarching judicial philosophy, they disagreed a fair amount of time, particularly on Fourth Amendment cases. Justice Scalia, and I guess I'm generalizing, but Justice Scalia was a very strong defender of criminal defendants' rights or criminal suspects' rights, and issued a lot of decisions that, if we're being just kind of labeling broadly, we'd say are pro-criminal defendants, because he essentially took the view, just like we need to be vigilant about things like the independent counsel stuff, just like we need to be vigilant in protecting the structure of our government, and like we need to be vigilant in protecting our First Amendment rights, we also have to be vigilant with Fourth Amendment rights. And sometimes that means that bad people might get away with things, and we're not going to like it very much. But those rights are ultimately there to protect all of us. And that's not to say that Justice Thomas would disagree with that statement, but you can find a number of cases where they actually reached opposite conclusions about Fourth Amendment issues. Justice Clarence Thomas tends to be a little bit more maybe forgiving of police action that's challenged on constitutional grounds than Justice Scalia might be. There was a case from, I forget when it was, just a couple of years ago now, Navarrete case. It was a case where an anonymous tipster called 911 and said, I just got run off the road by a car, and here's his license plate. I think will drop. The dispatcher alerted the police officer. The police officer found a car matching the description that was given by the caller, pulled it over based on the idea that we'll have reasonable suspicion this person's driving while intoxicated. And while searching, dealing with this stop, they found a bunch of marijuana in the car. And the criminal defendant challenged the case, saying, "You didn't actually have reasonable suspicion, to pull me over. Just this some anonymous tip by some person who described some car isn't enough." And Justice Thomas wrote the majority opinion in that case, saying, "Well, actually, that is enough," and that's the decision of the court. The way the Constitution is interpreted today is that a police officer would be acting within the constitutional bounds for pulling someone over in that position. Justice Scalia dissented, and in true Scalia fashion, he held nothing back, even though he was essentially challenging the man who's closest to him in thinking. And he wrote that the court's opinion serves up a freedom-destroying cocktail. That's vintage Scalia. His opinions are a joy to read. The rhetorical flourishes in them are quite. It's the type of thing that you sit there and think, I couldn't come up with that in 100 years if I tried. I think it's a great example. He was always committed, principled, and strong in defending his point of view. And in this case, it meant two conservatives disagreed on an issue. It was a good faith disagreement, and that's going to happen sometimes among judges. Also, in the Raich case, Raich was a case that was decided when I was in law school. It dealt with an individual who was growing a small amount of marijuana in their house solely for personal consumption. And the issue was, is that really part of interstate commerce? And can the federal government really regulate it? Justice Scalia ended up, in that case, concluding that it is part of interstate commerce, which is actually, I mention this because in law school you have a lot of time to actually think about the Constitution. As a lawyer, you don't get much time to think about the Constitution. But as a law student, everybody was in constitutional law. We knew this was an important case before the court, and there's very much a big issue among in Supreme Court judicial history about, well, what's the extent of the Commerce Clause? Of course, the Commerce Clause has been used to justify almost every example of federal overreach, or maybe not overreach, maybe it's legitimate reach, but it's been used to really expand the scope of the government over time. And the first case that really expanded it dealt with a farmer who was growing some wheat on his plot of land for his own personal consumption. So there were a lot of conservatives who maybe were not in favor of marijuana growth, but who said, oh my gosh, Justice Scalia shouldn't reach this conclusion because he's effectively putting, I guess, the war on drugs ahead of limiting the scope of the Commerce Clause. And however you come out with that is, it's not the point. The point is that I think, I'd like to emphasize that the people who are making these decisions have hard choices to make. In that case, he got some criticism from conservatives, but he's still clearly a leader of conservative thought on the bench. The other point that's worth, I think, thinking about is, at least when he was alive, we had 5 justices in the last few years who had been appointed by Republicans: Scalia, Thomas, Roberts, Alito, and Kennedy. And Justices Scalia and Thomas are the only two who would say that they really believe in originalism as an overarching interpretive method. Justice Alito has said he believes in originalism, but there may be cases where it's not the right interpretive lens to use, or some other interpretive lens that's more proper to that case. And then Justice Roberts, he talks more about, well, the interpretive lens depends on what the case is and what the issues are for the court. Justice Kennedy, I don't know what lens he uses. He has a different approach. But the point is that not every Republican appointed justice on the court, even among the conservatives, I think we, broadly speaking, have to include at least Roberts and Alito among conservatives, even if sometimes certain decisions feel criticized. And maybe Kennedy too. there's a range of constitutional thought there. And it's important to note that because of what Justice Scalia um, talked about his goal being. Um, he really talked about the idea that when he wrote all these dissents, these scathing, fun to read dissents, that ultimately his audience was, yes, the other members of the court, and yes, the country at large, but mostly it was law students. And he was writing for them because he knew that if you write a dissent that's so engaging, so fun to read, so interesting, the professors who write casebooks are going to have to put that dissent in the casebook because he's got to engage with it and it's fun to read. And he wanted to therefore use that as an opportunity to get law students thinking about, well, how should the Constitution really be interpreted? I think there's at least one person in the room who's heard me say this before. But when my wife and I, when we went to law school, we were a couple years apart, but we had the same professor for constitutional law. And on the first day of class, he told us, we're not going to read the Constitution. It's worthless. It's pointless. The text doesn't matter. And he really believed that. The text doesn't matter. And that's, of course, the view of the majority of professors who we encounter in law school. But it's nice to know that you had a man on the Supreme Court who knew, I can kind of be the extra professor in all these law students' casebooks, the one who writes these dissents that have to be read. And he really, as a result, had an oversized influence on the development of the law in the last 25 years-ish. Now Supreme Court Justice, then Dean of Harvard Law School, Elena Kagan, an Obama appointee, in an event regarding Justice Scalia, I think 4 or 5 years ago, said his views on textualism and originalism, his views on the role of judges in our society, and the practice of judging have really transformed the terms of debate in this country. He is the justice who has had the most important impact over the years in how we think and talk about law. And we know that once she became a member of the court, he actually judged with Elena Kagan too. And Justice Kagan, of course, doesn't agree with Justice Scalia's approach to the Constitution or to judging. But I think she was being honest here in pointing out that this is a man who's deeply unpopular in the law schools, or at least among law professors, and unpopular among kind of the mainstream thinkers. But his ideas were so engaging and so well presented that he's had this huge outsized influence. Ronald Dworkin, who's a liberal philosopher, a while back, probably more than a decade ago, said we're all originalists now. That's not true. There's many, many people who are not. But his point that actually originalism is now thought of as a respectable way of approaching the Constitution, that is the case. And that's a big change, thanks to Justice Scalia and really Justice Thomas. What's his impact on lawyers? I'm not really sure. With question marks there for a reason. Unfortunately, I think there's a lot of us who go about our daily jobs and don't think about the larger role that we're playing within shaping a system that really ensures rule of law for everybody. I wish more of us thought about it more often. So he's had a huge influence in the law, but as I said, he was a man. He was somebody who realized my career isn't everything, even if I'm on the Supreme Court. And I think it's worth, especially in a group that probably includes a lot of conservatives and a lot of people who think it's good, talking about his faith. Because Justice Scalia, I don't think you can understand Justice Scalia without understanding the role of faith played in his life. He was a lifelong Catholic who went to Mass very frequently, was very religious. As I said, his son became a priest. He was actually a frequent Latin Mass goer, which if you're Catholic, you know that people who go to Latin Mass tend to be more conservative in the Catholic world. And he talked about that his faith shaped him, was important to him, that his relationship with God was very, very key to who he was. But he also talked about, well, I'm not a Catholic judge, though. I'm a Catholic, I'm a Christian who cares deeply about my faith, but I'm not a Catholic judge in the sense that a judge shouldn't be sectarian, shouldn't be deciding things based, again, on their personal preferences. And he really explored that issue, I think, in a really, if you have a chance to read it, he wrote this article for First Things, which is a religious journal, in 2002, where he talked about faith and the death penalty. And he concluded that both under his own views or his legal views. He thought the source was exceptional in his constitution. He also said he felt that under Catholic thought, as it had developed over the centuries, that it was acceptable. But he talked about the idea that we can't separate things completely. And he said, I don't have a qualm about the death penalty as a judge. But if I did, if I concluded that it's immoral and that I simply cannot ever decide a case that would allow the death penalty, then I have two options. I could say, that's my personal preference and I'm going to impose it on the law. Or I can do the right thing, which is his view of the right thing, that if you truly have this conflict, you have to decide. Because the oath you take as a Supreme Court justice isn't an oath to do what you think is right. It's an oath to say the Constitution says this. And if you can't morally do that, then you have to, of course, do the moral thing first and resign from your position. Archbishop Charles Chaput, kind of a conservative leader among the American bishops, talks about Justice Scalia was a man of extraordinary genius and fidelity to the Constitution, but the larger part of his character was his enduring Christian character. His life as a husband, father, friend, scholar, and judge, shaped profoundly by his Catholic faith. What makes him great, and the only way that finally matters, was his moral integrity. And that, to me, is really key. There's two things I want to mention. Both are kind of fun before we have some questions. First is, if you have a chance, Justice Scalia gave a long interview with New York Magazine in 2013. And in that interview, he talked about a number of different topics. And it's really kind of fun to read. But one of them, religion, came up, and he mentioned belief in heaven and hell. And the interviewer, kind of this almost amusingly stereotypical kind of progressive newspaper interviewer, said, I'm quoting, "You believe in heaven and hell?" And he said, "Oh, of course I do. Don't you believe in heaven and hell?" And she said, "No." He responded, "Oh my." And they had this long discussion about it. And about, he then leans in. And you can almost see him doing this. He says, "You can believe in heaven." And she says, "You can't. Yeah, you could be religious, but you can't believe in heaven." And he talks about it a bit more, and he talks about, well, what does the devil mean, and how does he involve himself in the world? And this phrase here, I think, is very key, because a lot of people we know, especially after this last election, are very fed up with kind of the mainstream media voices that brush aside the views that a lot of people have between the toes. And this encapsulates it. The interviewer said, "It's really terribly frightening." And he said, "You're looking at me as though I'm evil. My God, are you so out of touch with most of America, most of which believes in the devil?" And goes on from there. He says, you travel in circles that are so removed from mainstream America that you are appalled that anybody would believe in the devil. And it goes on. This has been a belief throughout most of history. The reason I mention that is it's vintage Scalia. He doesn't care what she thinks. He just says what he believes. And that's, I think, the appeal of the man. His decisions on the court are extremely important in terms of the impact they have on the law. But he's also, as a human, as a person, just an engaging, fun character. And if you have a chance, it's just to interview some of his decisions. I'll point out the other thing. This picture, I think, is one of my favorites of Justice Scalia. He came to President Obama's second inaugural in 2012 wearing this hat. It's the hat of St. Thomas More, who was Chancellor of England and was martyred by Henry VIII. He's kind of a hero to many Catholic lawyers and judges. And it was given to him when he gave a speech at a Thomas More Society event. And, of course, when the point is here he was at the inauguration of a president of the United States who we can only assume he probably did not vote for, who had definitely done some things with regard to religious liberty that I think we can assume Justice Scalia probably on a personal level did not agree with. And many people thought this was a sign, him kind of his little resistance to Obama, we'll put it that way. He said, no, I was just wearing it. But I think this is a man who It's a funny hat. I mean, let's acknowledge it. If somebody probably all thinks he's a weirdo, right? But this is a man who didn't care. He said, "This is what I believe. This is what I think is true, and I'm going to do the right thing, um, regardless of what others may think." And it's clearly, I think, what he was doing with that hat. So, if you have any questions, I'm happy to answer.
Microphone is available for questions, so people online can hear.
Not really a question, it's commentary, I guess. I reviewed a couple of things. I took probably backdrop is you're talking about.
No, I went to Ohio State.
What Reno versus American Arab anti-discrimination?
I've heard of the case study.
He wrote the holding of the court, and this was in 1998. And it's so prophetic that it makes Nostradamus look like a rookie. Regarding the defense of this fellow who was getting deported was that 8 U.S.C. Section 1252 U.S. Code was being selectively enforced against Islam. Well, here's what this is what's struck. This was Scalia's only part of it. The doctrine of constitutional doubt does not require that Section 1252G be interpreted in such fashion as to permit immediate review of respondents' selective enforcement. Here's the good part. An alien unlawfully in this country has no constitutional right to assert that such a claim is a defense against his new constitution. So this sounds like it's ringing true to similar things that are going on today. In a hypothetical case that might come up, how difficult is this going to be to overturn? In your opinion?
Gosh, I know you just read it to me, and I may have read that decision before. I'm not sure if I have. I mean, there's some people who read like every Supreme Court decision and will remember every word of them. I'm not one of them. I'd have to reread it. But I think I think the larger question is about, to the extent that we have majority opinions by Justice Scalia, what's likely to happen to them going forward? And that raises, I think, a good point about, we now have Justice Gorsuch on the court. And I'm very, very happy about that. I'm sure many of you are. And I think he very much is a judge in Scalia's mode of thinking, and that we're probably likely to get a lot of decisions from him that are similar to decisions that we've gotten from Scalia. Not all of them. Justice Gorsuch disagrees with Scalia on Chevron deference. A lot of conservatives say, good. The really key thing is really the next C-level court. If there's another vacancy, because right now, as happy as I am about Justice Gorsuch, all it really does is effectively restore things to where they were right before the day he died in February 2016. We have essentially four, we'll call them conservative justices, or we can call them liberal justices, and one sort of left Justice Kennedy, who it's hard to categorize. Sometimes you might call it a little, maybe not, maybe more of a liberal. But if there's another vacancy, and if it's Justice Kennedy, or one of the four liberals, if there's an opportunity to appoint another justice like Gorsuch in the Scalia mode, that's where we could see real, I think, change with the Supreme Court. Because we've been in this kind of 4-4-1 system about 20 years. It really hasn't changed much. And I don't know about that particular case that you're talking about, but what I hope to see is that we have an opportunity to the extent that there may be a vacancy, a what happens. I hope it's a resignation, not something else. But to advance these ideas that have been so well articulated by Justice Scalia and kind of hopefully return the Supreme Court to having a majority that really believes that its role isn't to decide the law, but to decide, well, here's what the Constitution says, here's what it actually meant at the time. Is history all things to this country. And we'll see. So with your specific case, I'm not sure.
Isn't it more likely to be Ginsburg who retires and how's it quits?
If you're talking about retirement, I doubt she'll retire. I mean, I think she's going to going to want to wait until there's a Democrat in president. So who knows? I mean, there's speculation about Justice Kennedy. Would he maybe feel more comfortable retiring now that he knows that Trump appointed Gorsuch and Gorsuch is very respectable? Maybe, but Kennedy also kind of made some noises that kind of sounded like he might want to wait until a Democrat was president. So, maybe, stuff like that.
This question before who would you like to see as the next book?
Me? Oh gosh. Well, nobody's going to ask me, but they will ask the Federalist Society. I think it's very important to know that. This is all public knowledge. There's been lots of articles written. Leonard Leo, who's the executive vice president of our organization, who runs the organization, IPC, was essentially the person who recommended, at least by most reports, who recommended and really pushed Justice Gorsuch to the president. I think we all, I think we can all admit that President Trump, he's not a lawyer. I don't think he's really a legal thinker, and I think it's very good and very promising that he's listening to Leonard Leo and people like him. I think the president does take seriously his nomination authority. I think there's a lot of good people. You hear, well, we know, I think, the final three names, including Thomas Hardiman from the Bill Pryor from the Fifth Circuit in Alabama, and some others, and I suspect you'll probably see those same names pop up again. And the fact of the matter is it's been maybe about 100 years or more since anyone was appointed to the Supreme Court from anything other than the U.S. Court of Appeals. So when you're looking at U.S. Court of Appeals judges as probably the universe of possibilities, there's only a few hundred of them. And among those, there's only, let's say half, that's probably overstating things, who would agree with the president's way of thinking. And then with those, only a smaller number who are originalists. And then in those, only a smaller number who are in the right age range. Because, of course, a president wants their justice to be there for a few decades. And it's only a handful of people. And I really suspect that it'll be one of those. You hear some people have promoted a state Supreme Court justice, Charles Kennedy from Florida, Tom Lee, who's a state Supreme Court justice in Utah, and the brother of Senator Mike Lee. There's a lot of good judges. And I want to just, I'm not here speaking on behalf of the Federalist Society, but as somebody who's a member of it and involved in it, I think it's wonderful that we have an organization that has taken the time to promote originalism, textualism, and respect for the Constitution among lawyers. And we have, as a result, I think more people who would be in Justice Scalia's mold today than we would have had 20 years ago. Some people, a lot of times, we conservatives say these Republican presidents, even Reagan appointed Connor, Kennedy, and George H.W. Bush appointed Souter, and it's true, some of those nominations didn't really work out. But you have to look at it, I think, also from the lens of history, and the fact of the matter is the available candidates in those times didn't include many people who thought like Justice Scalia. That's one of the great things about him, is now there are people who think that way. There's a lot of great candidates who knows. And I wouldn't put it past President Trump, if he has an opportunity for another nomination, to maybe be the first person who reaches beyond the Court of Appeals and maybe goes to the Supreme Court or maybe even a federal district court, trial court. Uh,
My name is Leslie. I like Scalia, who's my favorite judge, and a lot of respect for him. However, I confess I don't have a lot of respect for the Supreme Court in general. And I think a lot of the appointees are PC. Some of the appointees were PC appointees. So here is it's a personal question for me. Do you think that our justices should have a top out age when they are forced to resign from the bench instead of hanging on into their mid 80s and beyond, but maybe their reasoning capabilities aren't as sharp as they were when they were younger?
I'm open to that idea. I get nervous whenever we talk about changing structure. The Constitution says for life, and if we make that change, it has to be constitutional change. I think our constitutional system of government is amazing, and there's a lot of benefits to lifetime tenure in terms of judges taking the role seriously. But there's some drawbacks too, and I'm open to the idea of the topic. I'm not firmly committed to it, but I think it's worth discussing. And there's been other proposals too, like having terms of let's say 20 years or something like that. I think the worry is, of course, if we do that, that we criticize the court even more, because then well, next year just so and so is leaving, so let's plan for that vacancy, and there might be unintended effects that we can't look now. But I'm open to that.
I think we have time for two more questions here.
Good. Maybe it's out there. I haven't seen it. Scalia, did he ever have an opinion on the Ninth Supreme Court?
On the Ninth Circuit? If he did, I'm not aware of it. I mean, there were plenty of Ninth Circuit decisions that were appealed to the Supreme Court, and that he would have reviewed and reversed the Ninth, been in part of a majority that reversed, or maybe a minority that didn't reverse. But I'm not aware. Maybe somebody better versed than him in the speech than me would know. Not aware of anything specific he said. I think I like to tell people this locally. It's interesting. The Ninth Circuit has had the highest reversal rate for a long time, except its chief rival to that title is the Sixth Circuit, based here in Cincinnati, that includes Ohio, Kentucky, Tennessee, and Michigan. And for a couple years ago, there was a 1 or 2 year stretch where the Sixth Circuit was reversed even more than the Ninth. And the Ninth Circuit is out to lunch. I mean, there's lots of decisions that come out of the Ninth Circuit that are problematic. If you want to talk about, here's a reform, maybe you split up the Ninth Circuit. I think that's worth thinking about. But we also, when thinking about reversals, have to realize that, say I have I'm in federal court a lot. Let's say I win a case in federal court here, in district court, and gets appealed to the Court of Appeals. Those judges don't have a lot of discretion in whether they do that appeal or not. But if you appeal from the Court of Appeals to the U.S. Supreme Court, they have almost complete discretion. They vote, are we going to hear this case or not? And you have to have 4 votes for the case to be heard. And so they limit their docket really well, compared to, the Court of Appeals judge, they may do a couple of thousand cases a year, or 1,000, I forget the rules. It's a lot higher. The U.S. Supreme Court deals with like 120 to 150 cases in a year. And most of the time, they're accepting the case because they want to reverse it. So all the circuits are going to have a fairly high reversal rate, but the Ninth is a different animal.
I have 2 questions. One is kind of a reflection of the bullshit of government. But if you were a current
we'll talk about all these books, textual, able, and the second question is, will the deaf, dumb, and black, sun black, I will look most important. Why will sort of
Okay, there's three things I want to mention, and I'm going to write them down so I don't forget, because I'm not that good at opening into other stuff. I really want to answer that, but before I forget, there's a point I forgot to mention with your question. It's really important that we remember that when federal, district, and circuit court judges are nominated, the tradition in the Senate for a long time has been this blue slip process, where we say, yeah, the president has the appointment authority, but if Senator Smith from that state says they don't want the person, they're not getting through. And I'm very pleased. I know Leo has talked about this, and we're starting to see news reports from the White House and from Senator Grassley, who chairs the Judiciary Committee, that maybe we can set this blue slip process aside. And that blue slip process is part of why the Ninth Circuit is the way it is, because you have so many judges from California, because California senators have said, nope, 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 nope. And if we get rid of the blue slip process, it'll be interesting to see how the appointments go. It's your question. If Scalia, you're saying if Scalia were put up today, how might we challenge him? The same way we challenge every other judge appointed by a Republican. I mean, of course, you know the script. This person's gonna take away this right and take away that right, and they hate employees, blah blah blah. And you know, you would see, oh, look at this religious man, he's a nut job for his faith, and it would just be the same as everything else. I mean, he was the faculty advisor to the Federalist Society. I mean, we know with Justice Gorsuch, we criticized him for being associated with the Federalist Society. With Judge Thapar from Kentucky, he just got nominated to the Sixth Circuit Court of Appeals. They went after him for speaking of the Federalist Society. That's one of which he's spoken our chapters before. They'll probably do anything they want before. And it is important to remember that when Scalia was confirmed to the Supreme Court, I forget the exact number. I think it was 97-0 or 99-0. I mean, it used to be that as long as the judge was qualified, the Senate was willing to put them through. And when Judge Bork was nominated, and you had the whole confirmation hearing fiasco with him, which Democrats led, and then they tried the same thing with Justice Thomas, it changed things. But we can blame the Democrats, but it's also the justices on the court who are to blame, I would say. Because as long as justices make decisions that are political decisions, it's no wonder that people have an interest in choosing people who align with their politics. If you had more judges who said, I'm going to set my politics and my personal views aside, and I'm going to decide things based on, as objectively as I can, what the Constitution or the statute says, regardless of my preferences, if they really did that, or at least if we really trusted that they were doing that, I think we could have some less contentious confirmation there. As to his death, I mean, I know there's people who speculate, but as far as I've seen, the family was very confident that he died of natural causes. I believe that.
Well, I want to thank everybody for coming tonight. Let's give our speakers a round of applause.
Thank you.
Thank you.
Thank you. Thank you very much.
And one thing I do want to mention, when I mentioned the class we're going to have on June the 17th on a Saturday, there's a $25 charge for that class because you get 2 books and you get 2 books so far. But if you have a family, I believe it's 25 for one person and that's 5 for each child. So anyway, put that on your calendar if you know anybody that this is a great book, especially for millennials and college kids. So thank you very much and have a great night.